Hi, everyone. My name is Sadia Mirza. I am an attorney at Troutman Pepper, and I'm part of the Cybersecurity, Information Governance, and Privacy Practice Group. I've had the privilege of presenting at the last CCPA forum last year, and I was thrilled when they asked me to come back again. And I'm hoping, to this time around, I'm speaking on incident response in the era of CCPA. And I think it's just such a timely topic right now, given what we're seeing given what we're seeing, the number of incidents coming up, the types of litigation that we've been seeing coming out of the CCPA. So I'm hoping everyone in the audience takes away something valuable from this session. I'm going to go ahead and move to my next slide. Here's a quick bio on myself. Again, I'm at Troutman Pepper, part of the Cybersecurity, Information Governance, Privacy Practice Group. When the CCPA first came out, a large part of my practice was really dedicated to privacy compliance, getting organizations ready for the January 1, 2020 date. And it was just about 2 years of compliance work. And a large bulk of my practice is really incident response as well. And I think I'm starting to see a lot more come back now that we're moving away from the privacy compliance and in the wake of the CCPA notice and cure provision, the statutory damages, and just the uptick in incidents. A lot of my practice has now shifted away from CCPA privacy compliance to incident response, but still with the overlap of the CCPA. And so again, today we're going to be talking about incident response in the era of CCPA, and what does that mean? And I think there's a lot of myths out there about whether or not the CCPA changes data breach laws in the United States. And that's what I wanted to talk about. And I thought the best way to start this topic off is really to give you an overview of data breach laws and information security laws in the U.S., putting the CCPA to the side for a second. My first slide it's really a quick overview of data breach laws in the U.S. And what's important to know here is that all 50 states and certain U.S. territories, including Guam, Puerto Rico, and the Virgin Islands, have passed their own data breach notification laws, which tell us when do you need to notify residents in the event of a breach. So what you should know about this is that the laws are similar, but they're not identical. Every data breach notification law will tell you what is a breach, what qualifies as a breach. So some states say, if personal information has been accessed, is subject to unauthorized access. Some states will say subject to unauthorized acquisition, and it's important to understand, the differences between the two. And so from there, they move on to say, well, what types of information is actually protected? What is PII under the breach statute? Meaning, if this type of information, this PII is compromised, that would likely give rise to, whether or not it's actually a breach. And so, you see a lot of similarities in the laws about what qualifies as PII. And across all 50 states, you're going to see things that you normally consider sensitive. Social security numbers, government identifiers, driver's license numbers, the types of information you would actually believe, you would consider sensitive information. So that type of information is usually always considered PII. But some states take it a step further, and they say, well, even an email address with a password, if that's exposed or compromised, that could qualify as a breach. Or certain states take it even a little bit further and say, a date of birth, even a date of birth could be considered personal information. So you have to pay attention to what does the law consider to be, what does the state consider to be sensitive or protected information under the breach notification law. These statutes will also tell you who needs to be notified. So all of them will say that you need to, in the event of a breach, you need to notify consumers. And the consumers are the residents of that state. Certain states will also say you need to notify the AG or other regulators. So you'd have to pay attention to, if you've understood that there's a breach, who do I owe a notice to, and who do I need to inform about the breach? It's also important to pay attention to the reporting deadlines. And this is, why there's always a bit of a, time is of the essence in incident response, because the notification deadlines creep up rather quickly. Certain states say you need to report a breach to residents within 10 days. So that's like a Puerto Rico requirement. Other states will say 14 days. You need to give at least a preliminary notice to the state within 14 days, and I believe that's a Vermont requirement. A lot of the statutes say, okay, well, you need to notify residents of the breach within 30 days. And so, the point to really be aware of is that the law, it varies depending on what state residents you're looking at. And you should also, I think this is a good time to mention, there's language in these statutes that talk about, when does the deadline, when does the clock start ticking? And I've dealt with a number of incidents, and I've talked to some regulators about this, and there is an opinion that this clock really starts ticking once you've determined the nature and scope of the incident. And so that language gives a lot of comfort in terms of you have some time to do your investigation. But again, you want to confirm, you want to take a look at the language in the statute to see if that exists, and if it aligns with that, with the fact that the clock doesn't start ticking until you've confirmed that information. The statutes also vary in terms of what needs to be included in your notification to consumers. Do you need to tell them, do you need to give them the contact information for AGs or certain, do you need to tell them to notify law enforcement? Do you need to offer credit monitoring? And so these are all the variances that you might see in a data breach notification law. And the takeaway really here for me is, if an organization, let's say an organization is based in California and they experience a breach, but that California-based organization collects personal information on consumers or residents across all 50 states. When they're doing their data breach notification analysis, they're not only going to look at the California law. The law applies depending on where the resident lives, where the consumer lives. So if I'm a California organization and I have PI on consumers across all 50 states, unfortunately, we're doing a 50-state analysis to figure out which consumers are getting, who needs to, where does this incident actually qualify as a breach? And so that's important to understand too. Just because it's a breach in California doesn't necessarily mean it's going to end up being a breach in a different state, because again, what qualifies as a breach, what information is protected, all of that varies by state. There is like a baseline, if you've exposed social security numbers, you can just confirm, if social security numbers have been acquired, there's a good chance it's a breach, and you need to get ready for that. But if it's, if you're looking at email addresses and passwords or something a little bit where there's not a consistency of whether it's considered PI, you really have to do that full 50-state analysis to understand that it qualifies as a breach, and then again, to understand what are the next steps. And so going on to the next slide, I thought it'd be helpful, because we're going to talk about this in the context of the CCPA. So what's a breach in California? So I have it up on my screen right now. A breach means the unauthorized acquisition of computerized data that compromises the security, confidentiality, or integrity of personal information maintained by the person or business. There's a couple of things when we talk about this in light of the CCPA. There's a couple of things that I like to point out here. One, this data breach notification law, it's referring to personal information. And now we all know that personal information under the CCPA is defined very broadly, right? It's anything under the sun, anything that reasonably relates to a particular consumer is personal information. However, when we're considering whether something is a breach, we are not looking to the CCPA definition of personal information. We're looking to California's breach law to figure out what is personal information. And so I think there's a lot of confusion there. And this is a point that everyone should understand, is that the data breach notification law does not rely on the CCPA's definition of personal information. I have up on my screen what is considered personal information in the context of the data breach notification law. And again, it's things that we have talked, it's like a social security number, a driver's license number, medical information. California is one of the states that says a username or email address in combination with a password or security question, account number in combination with a required security code. These are the types of data elements that could trigger California's breach notification obligation. It is not just anything related to a consumer. We wouldn't look to the CCPA to tell us what is personal information when determining whether something is a breach. And so we talked, so that's an overview of data breach notification laws, but we also need to understand that there's also information security laws in the United States. And the one thing that I've always said about the CCPA is that the CCPA is not an information security law. It is a privacy law, and the goal is to give California consumers certain rights over their personal information, like giving them notice about what personal information a business has collected, giving them the right to access that information. What the CCPA does not do is it does not say, businesses, you guys need to protect personal information in this way, or you need to protect personal information, period. That is not what the CCPA is intended to do. That comes from a different California statute. We have California Civil Code 1798.81.5, which says that a business that owns, licenses, or maintains personal information about a California resident is required to implement and maintain reasonable security procedures and practices. And so again, while there's this concept of protecting personal information under California law, it does not come from the CCPA. And that's another one of those myths that I think that's out there, that the CCPA is a data security law. It's not. And so again, that concept really comes from this other information security law from California. It's worth, I put it, this is a whole different conversation, but I put it here, and the question always comes up, well, what is reasonable security procedures and practices? I'm sure everyone in this room knows by now that there's really no fixed standard for what reasonable security is. It depends on the size of your organization, it depends on the type of data you collect. But a lot of organizations, there are basic building blocks of what's considered reasonable security that's rooted both in law and in industry standard. And so you can look to things like the NIST cybersecurity framework, the top 20 CIS controls, which the California AG actually came out and said, I think in 2016, that these CIS controls represent the baseline security. And then even within law, certain laws are a little bit more prescriptive in what is intended to be required for to maintain reasonable security, such as the New York Shield law. But so now let's bring this back to, this whole form is about the CCPA. And so let's talk about with that understanding of how data breach notification laws work and understanding that, the CCPA is not an information security statute. Let's talk about data breaches and the CCPA and how the two things actually overlap. So I have up on my screen, if you've been reading through the CCPA or reading about it, you understand there's really two different types of statutory damages or damages that can be assessed through the CCPA. One of them are to the left of my screen are what I call the CCPA violations. This is a number that if an organization is found to have not complied with the CCPA by the AG, let's say for not giving adequate notice, for not complying with an access request or deletion request, the AG right now is supposed to give businesses a 30-day window, an opportunity to cure, and if not, can bring an enforcement action for these damages to the left. Those are CCPA privacy violations, and that's how I kind of categorize those. To the right, however, and this is where the data breach notification laws become important, are the statutory damages that consumers can bring in the event of a breach. So what the CCPA says is that a consumer can sue an organization whose personal information has been compromised as a result of the business's failure to maintain or implement reasonable security procedures. And then the damages, and then it provides these statutory damages, which are up on my screen on the right. And so this whole concept is really we refer to it as the CCPA notice and cure provision. And I think it's worth breaking down a little bit more. So CCPA allows consumers to bring an action for statutory damages in the event of a data breach due to the failure to implement reasonable security procedures and practices. And so you have to remember that, that obligation to implement reasonable security procedures and practices, it doesn't come from the CCPA, right? That is a different statute, and we talked about that earlier. But what the CCPA is saying is, okay, well, if you failed to maintain those reasonable security procedures and practices, and as a result, there was a data breach that compromised personal information, then consumers can bring an action for statutory damages. And again, the thing to remember here, and I think this is why there's confusion, is this is not based on the CCPA definition of personal information. Even though, the statutory damages it's being provided through the CCPA, we're still talking about data breaches. And it's still going to be, a data breach can only occur if the information outlined in the breach notification law has actually been compromised or, subject to acquisition as defined by California. And so, these are the high level takeaways, I think, for the notice and cure. And so before a consumer can bring an action for statutory damages, what the consumer is supposed to do is provide businesses a 30 days written notice identifying the violation and an opportunity to cure. If the business cures a violation and provides written notice indicating such, then statutory damages are not available. So let's unpack that a little bit. So let's say that a consumer believes that a breach has occurred and says it's because you guys failed to implement reasonable security procedures and practices. Prior to initiating a lawsuit, the consumer would write you a nice little letter saying, okay, you have failed to implement reasonable security procedures. We're going to sue you under the CCPA. We have this right to sue you. Once the business gets that letter, the business is supposed to respond to it. If the business is able to cure, the alleged violation, then statutory damages would not be available. And so the entire question around this whole concept is, well, how do you cure a breach? What does that mean? And I think that really has been the $1 million question when it comes to data breach and the CCPA. And I'll tell you, moving on to the next screen, I think, unfortunately, there's not going to be a single answer on how to cure a breach. There's not going to be, again, like how we kind of talked about reasonable security procedures and practices, it's going to vary based on the type of incident and maybe even the types of information that has been compromised. If not, there's not going to be a fixed way to do this. But what we've been advocating here at Troutman is that really the best way to cure a breach, it's going to take a holistic approach to incident response. So there's not just one certain thing that you'll need to do. You'll need to look at it from several different factors. And so breaking this down a little bit more, one of the things we said is, okay, the consumer has to identify the specific violation and you need to cure that violation. So in this case, the violation is allegedly the failure to maintain reasonable security procedures and practices. So part of your response, is addressing at least that issue, is considering, are you going to take the position that you always maintained reasonable security procedures and practices, and therefore there is nothing to cure? Or do you say, okay, well, we understand that there are certain steps that we need to take, we've taken it, and now we've cured it that way. So that's one thing you'll want to take into consideration. Maybe the cure involves consumer education, telling consumers, how can you guys, how can you further protect your information? Although this incident has occurred, what steps do you need to take? And you see a lot of that in like the notices of data breach that, at this point, I'm not even sure if consumers are reading, just given the number of notices that go out. But if you actually read through those, every organization tries to give you steps to take, whether it's signing up for credit monitoring, whether it's contacting the CRAs, fraud alerts, there's various things you can do. And so maybe part of your cure is educating the consumers about what they can do to protect their personal information that may have been at issue. Another thing, a concept is, providing prompt notice. I think that goes a long way in curing a breach as well, because the sooner you're able to notify the consumers, the faster they'll be able to respond. Maybe it's not even enough time for the threat actors to take advantage of any of the PI that was at issue. And so providing prompt notice might be a factor taken into consideration. Again, identity theft prevention services, maybe actually offering credit monitoring is something that's included as part of the cure. And again, so the reason we say that it's not going to be a fixed answer for everyone is because, maybe identity theft prevention doesn't make sense for certain incidents. If social security numbers were not involved, and let's say the incident only compromised email addresses and a password, well, maybe identity theft prevention services may not help. And so again, you need to analyze the incident itself. You need to look at the types of information that may have been involved. You need to assess, the vulnerability or, the mechanism that the actor used to get in, and really assess it from a holistic approach as to what can you do to cure this particular incident. Once you do that, I think it's very important that we're now seeing a lot of CCPA notice and cure demands. It's very important to craft your language in response to these letters with the understanding, with the long-term understanding of what's to come from this. If, for example, if you're saying the reasonable security procedure and practices that you always maintain those, it's important to call that out, that, okay, we understand that you think that we didn't maintain reasonable security procedures. If you have any reason to believe that's true, please let us know. We have always maintained reasonable security procedures and practices, and therefore, there's nothing to cure. It may change depending on each organization, but it's very important to pay attention to the language. And I think, we've seen that for some organizations, the way that, this is taking a little bit back, the way this breach notification, the CCPA notice and cure damages are written, it really only applies to businesses under the CCPA. It does not apply to a service provider. And this is one of the things that we're seeing over and over again, is that service providers are getting hit with these notice and cure provisions because plaintiffs counsel don't understand this right now, that the CCPA doesn't apply to service providers. At least the statutory damages provision does not apply to service providers. The CCPA really regulates businesses as defined by the Act. And so again, when you're responding to these letters, if that's the position that you're going to be taking, that's something that should be in your written statement as well, right? That, okay, we understand that you believe that we violated CCPA, that we failed to maintain reasonable security procedures, and you're looking to get statutory damages. However, you should know that the CCPA does not apply to us because we are a service provider. And so you really need to have a good understanding of how the law works in order to be able to, in order to be able to respond to these types of letters. And again, going back to, our holistic approach to incident response, I think one of the key practical takeaways here is the value of having an incident response plan in place and understanding what organizations need to do in the event of an incident cannot be overstated, because there's a lot more on the line at this point, I think, with the statutory damages. And we've just seen a huge increase in really just even breach litigation, or putting litigation aside, regulatory inquiries coming out of incidents. And maybe that has something to do with COVID, or, I think we've seen so much more litigation around the breaches. It obviously has to do with the CCPA statutory damages, or I'm thinking that people just have more time to read the data breach notification letters at this point. I thought my husband pulled out a breach notification letter the other day and said, "Oh, I got this. What should we do?" I was like, "Nothing. Throw it away." I was like, "Put that away. I don't want to look at that." But I think there's people are reading a lot more, or paying attention a lot more, which may be resulting in some more activity in this area. I put this up on here, and you guys certainly, the CCPA, it made its litigation debut in February 2020 in a class action filed against Hannah Anderson and Salesforce. I think it's a good case to read and take a look at. We also published an article on this topic. I think it was published through Bloomberg, and it foreshadows how plaintiffs are going to rely on the CCPA. Again, in this case, it's the same story. The plaintiffs allege that the defendants violated the CCPA by failing to maintain reasonable security procedures. But as we discussed, the plaintiffs can't really, they can allege it, but it's not very accurate, because the CCPA doesn't require you to maintain reasonable security procedures and practices. And so if you take a look, if you actually go to my bio on troutman.com, you can, in the publication section, you can see the article there specifically. And there's a couple of other, some of the concepts that I talked about today, such as the notice and cure, this provision not applying to service providers. All that is kind of outlined in that article, so that might be a good one for everyone to take a look at and just catch up on. I know we just have a couple of minutes left, and the one thing, on the November ballot, we have CCPA 2.0, which is the California Privacy Rights Act. And I won't tell you how I voted, but maybe you'll guess towards the end after I tell you a little bit about this. So, there's a lot to unpack for the California Privacy Rights Act, and I know that there's an entire separate section dedicated to it. So I wanted to focus on just the sections that were relevant to what we just discussed: information security and data breaches. What really jumped out at me was CCPA 2.0, CPRA, actually incorporates California's information security statute into the text of the CPRA. And so I have it highlighted. It's in this little yellow box. And so this is straight from the CPRA. It says, a business that collects the consumer's personal information shall implement reasonable security procedures and practices appropriate to the nature of the personal information to protect the PI from unauthorized or illegal access, destruction, use, modification, or disclosure in accordance with section 1798.81.5. To me, it's interesting that they pulled this statute into the CPRA. And it gives rise to, some questions around, one, again, I think I read this because in the end it says in accordance with section 1798.81.5. I still read this to mean that, the obligation to protect this personal information is PI is defined under the data breach notification law. But I think that we're going to see some confusion around this issue, or plaintiffs will at least try to take advantage of this as, is this stretching the obligation to apply to all CCPA personal information because it's now actually in the text of the CPRA, or is it still limited to only personal information as defined by the data breach notification law? So I thought this was interesting. I thought it was also interesting that they pulled this language in because it'll be interesting to see whether or not, if passed, right? We don't know if it's going to pass, but if it's passed, whether or not it creates a new California Privacy Protection Agency, whether or not they're going to be able to administer fines for violation of this information security provision, which under the CCPA we can't do right now, right? And so moving on to the other, so I thought this was very interesting, and I'm sure this came out of all of the conversations around CCPA and how do you cure a breach. The language that got added to CPRA was, the implementation and maintenance of reasonable security procedures and practices following a breach does not constitute a cure with respect to that breach. And so, it's literally without words because, the question then still becomes, well, if the violation is you didn't maintain reasonable security procedures, a consumer can come back and say, you violated that. We're giving you 30 days notice to cure it. If implementing reasonable security procedures itself is not a cure, well, then, we're still back to that question. Well, how do you cure a breach? And I don't think our response changes. I read this to mean that, okay, this alone might not be the only way to cure a breach. You need to take into consideration other factors as well. And we talked about some of that, right? The credit monitoring, the consumer education, the prompt notice. And so again, it's going to be a holistic approach to incident response that will be key, but this certainly raises more questions than anything about, what are they thinking when they talk about curing a breach? And I think we'll continue to see more conversation around this topic in the months ahead. Bearing in mind, we just have a couple of, maybe even just like 2 minutes left. There's a couple of slides here at the end relating to incident preparation. I added them in here. I had a feeling we wouldn't be able to get through them, but I wanted to add them in here, and it talks about the value of an incident response plan. A lot of organizations go through the process of at least creating the incident response plan, and then they tuck it away up nicely on their shelf. But again, if you're going to go through that, you should, if you're going to take in the time to create the incident response plan, you really also want to test it and make sure that it works and identify any gaps or any holes that you guys might need to address. And again, the best way to do that, I'm sure everyone in this room already knows, is the value of a tabletop exercise. bringing everyone into the room and testing out the incident response plan to make sure that everyone knows their role in the event of an incident and how to respond. And so, this slide talks about the purpose. We have some, the typical type of content that you'll see in an incident response plan. We obviously at Troutman help a lot of organizations put these together and also assist with tabletop exercises. I'll leave this slide up here, and of course, if anyone has any questions, they're more than welcome to reach out to me. This is definitely an area of law that's not clear. I think, that's the theme of a lot of these laws that I'm discussing today. But if there's any questions about any of these slides at the end, please feel free to reach out to me. Again, my name is Sadia Mirza. I really appreciate everyone tuning in. If there was any questions about the topics that I discussed today, please feel free to reach out to me. My contact information is up on the screen. I'm happy to field any questions or discuss just about the topics otherwise. Thanks so much.